So, picture this. A trial has just wrapped up. The gavel has fallen, the judge has made a ruling, and a final judgment is entered. But for one side, it might feel like the story isn't quite over. In fact, a whole new and very different chapter could be just beginning. Welcome to the appeals process.
You know, this is the big question, the one that the entire appellate system is built to answer. And it's not about getting a do-over or a second bite at the apple. It's really about making sure the rules of the game were followed correctly. So what happens when one team believes the referee made a bad call and wants to take it upstairs for review?
And this chart nails the key difference. The best way to think about it is like this. A trial is the game being played live on the field. The appeal, that's the instant replay review happening up in the booth. The appellate judges aren't out there playing, they're just looking at the footage of the game that was already played to see if the trial court, the referee, applied the rulebook correctly. They can't look at new plays or bring in new players, they are stuck with what already happened on the field.
To really wrap our heads around this, we're going to break the whole journey down into 5 key stages. We'll start with what an appeal really is, then we'll look at how you kick things off, how the official story gets put together for the higher court, what the final arguments look like, and finally, why this whole thing matters so much.
All right, let's dive into part 1. What is an appeal? And if you remember one thing, make it this. It's a review, not a redo.
This quote from our source material really gets to the core of it. This is the absolute bedrock of the appeals process. The higher court is totally locked into what happened below. This isn't about what feels fair. It's a hard and fast rule. The time for new witnesses or a surprise email you just found, that's over. The book is closed.
Okay, on to stage 2. Kicking off the journey. And if you're the one who wants to appeal, you absolutely cannot afford to wait around. The clock starts ticking, and it starts ticking loudly the second that first trial is over.
And the party that gets this whole ball rolling is called the appellant. This is the person or the company that's essentially raising their hand and saying, hey, wait a minute, I think there was a major legal mistake here, and I want a higher court to check the work.
And this timeline shows you just how serious that ticking clock is. The moment a judgment is entered, a 30-day countdown begins. After that, the judgment is considered final. And from that point, you've got just 10 days. That's it, 10 days to file what's called a notice of appeal. If you miss that 40-day window from the start, that door can slam shut for good. These deadlines are incredibly strict for a reason. The system needs finality.
Okay, so you filed the notice just under the wire. Now the really heavy lifting begins. We're now in stage 3, which is all about building the case file, meticulously putting together the official story of the trial for the new judges to read.
This official story is called the record on appeal. And if we go back to our instant replay analogy, the record is literally everything. It's the complete, unedited game tape from every camera angle, plus all the official paperwork. It has every single word that was said in court, every document filed. It is the one and only source of truth for the appellate court.
And guess what? Putting this whole thing together is completely on the appellant's shoulders. They have to order the official transcript, hunt down all the legal documents, package it all up, and file it with the appellate court. And yep, you guessed it, there's another deadline, usually 90 days from when they first filed that notice. So, once that record is filed, it's time to actually make your argument, and that happens in what might be the most important document of the whole process, the brief. If the record is the game tape, the brief is the coach's detailed memo to the league officials, pointing to specific moments on the tape and using the official rulebook to argue why a crucial error was made.
And these briefs aren't just angry letters. They are incredibly structured. You have to lay out the facts of the case in a neutral way. Then you pinpoint the exact legal mistakes you're challenging. But the real meat of it is the argument section, where you explain why those mistakes were so important that they should change the outcome. And you end by telling the court exactly what you want them to do about it. And all of that work brings us to the climax of the journey, the final pitch, the argument, and, eventually, the decision from the appellate judges.
We've all seen it in the movies, right? The lawyer stands up, gives some powerful, soul-stirring speech, and wins the case right there on the spot. But is that really how appeals work?
Yeah, not quite. The reality is, if an oral argument even happens, and a lot of cases are decided just on the written briefs, each side usually gets a grand total of 15 minutes. It's not a big speech. It's a rapid-fire Q&A with the judges. The real battle was already fought and won or lost in those dense written arguments.
So after reading the briefs and maybe hearing that short argument, the judges make their decision. And they issue it in a formal written document called an opinion. This thing explains all their legal reasoning.
They might affirm the trial court, which means they agree with the results, or they could reverse it and overturn the outcome, or even remand it, which means sending it back to the trial court with instructions. But it's important to remember, winning an appeal is really tough. Most of the time, trial court decisions are affirmed.
Well, we've made it through the whole journey, from start to finish. But for our final word, let's just zoom out for a second and ask the biggest question of all. Why does any of this matter? Why have such a rigid, complicated, and frankly, difficult process?
The answer is that all of this structure, all the strict deadlines, the locked record, the formal briefs, it's all there on purpose. You could say that complexity isn't a bug, it's a feature. It's a system that's intentionally designed to be a critical safety net, a final check to make sure that justice is not just about who wins, but about making sure the rules were followed for everybody.
And that really leaves us with a final, fascinating question to think about. This process is, without a doubt, hard. It's expensive, it's time-consuming, it's highly technical. So, which is it? Is this complex journey an unfortunate barrier that makes real justice that much harder to achieve? Or is that very complexity the ultimate guarantee that our legal system can correct its own mistakes and, in the end, get it right?